Welcome to This Week in Education Law School Administrator's Guide, where I share up-to-date court decisions that shape our educational system. This is episode 28. In today's episode, we'll discuss a decision made by the U.S. Supreme Court regarding the U.S. Department of Education's Student Loan Forgiveness Program. We'll focus on how the court arrived at the decision and explore their implications. The central question at hand is not whether actions should be taken regarding student loans, but rather who has the authority to forgive student loan debt. In my previous video discussing school COVID policies, such as mask and vaccine mandates for students and school employees, we saw that most of those policies were upheld in courts due to the broad emergency power evoked under an emergency declaration. However, once the emergency declaration expired, the same COVID policy often did not hold up in courts. A similar issue of separation of powers arises with the student loan forgiveness policy amid the national emergency of the COVID-19 pandemic. The question at stake is, who holds the authority to forgive $430 billion of student loan debt? Is it Congress representing the legislative branch of the government, or is it the U.S. Department of Education, which is part of the executive branch? Let's look at the case Biden v. Nebraska. Title IV of the Higher Education Act of 1965 governs federal student loans. The Act authorizes the Secretary of Education to cancel or reduce loans in certain limited consequences. The Secretary may cancel a set amount of loans held by some public servants. He may also forgive the loans of borrowers who have died or become permanently or totally disabled, borrowers who are bankrupt, and borrowers whose schools falsely certify them close down or fail to pay lenders. The issue presented in this case is whether the Secretary has authority under the Higher Education Relief Opportunities for Students Act of 2003, also known as the HEROES Act, to depart from the existing provisions of the Act and establish a student loan forgiveness program that will cancel about $430 billion in debt principal that influence nearly all borrowers. Under the HEROES Act, the Secretary may waive or modify any statutory or regulatory provision applicable to the student financial assistance programs under Title IV of the Act, as the Secretary deemed necessary in connection with a war or other military operation or national emergency. As relevant here, the Secretary may issue such waivers or modifications only as may be necessary to ensure that recipients of student financial assistance under Title IV of the Act affected by a national emergency are not placed in a worse position financially in relation to that financial assistance because of the national emergency. In 2022, as the COVID-19 pandemic neared its end, the Secretary of Education invoked the HEROES Act to reduce or completely eliminate the federal student debt for most borrowers. 6 states, including Nebraska, Missouri, Arkansas, Iowa, Kansas, and South Carolina, challenged the plan, arguing that the Secretary of Education's student loan forgiveness program exceeded the authority granted to the Secretary of Education by law. The Eighth Circuit Court of Appeals issued a preliminary injunction that applied across the country. In a 6-3 decision, the Supreme Court held that the HEROES Act does not grant the Secretary of Education the power to rewrite the statutes to the extent of nullifying existing laws and replacing them with completely new ones by canceling $430 billion of student loan principal. Chief Justice John Roberts delivered the opinion of the court. The majority of the Supreme Court reached this decision for 2 reasons. First, the text of the HEROES Act does not authorize the Secretary's loan forgiveness program. The act allows the secretary to modify or slightly change the law, but it does not allow for significant changes to the law's basic structure. The term modify carries a connotation of increment or limitation and must be read to mean to change moderately or in minor fashion. Before the COVID-19 pandemic, the Secretary of Education used the power to modify to make minor adjustments to the HEROES Act. The changes being challenged now in court, however, represents a drastic shift, creating a completely new loan forgiveness program. While Congress specified in the Education Act a few narrowly delineated situations that could qualify a borrower for loan discharge, the Secretary has extended such discharge to nearly every borrower in the country. It's highly unlikely that Congress authorized such a sweeping loan cancellation program through such a subtle device as a permission to modify. The Secretary argues that the Act's allowance for him to waive legal requirements in addition to modify them gives him broader authority. However, his use of the waiver power in this case does not align with past uses, where it was used to negate specific legal obligations. The Secretary also suggests that the combined power to waive or modify laws would let him reduce obligations to any extent, even beyond the limits of modification. However, the challenged loan forgiveness program exceeds even this interpretation. Essentially, the Secretary rewrote a section of the Education Act by nullifying existing laws and replacing them with completely new ones. The Secretary also cites a procedural provision in the HEROES Act that requires him to publicize any changes or waiver to the law. Here is the original text in the HEROES Act. Waiver authority for response to military contingencies and national emergencies. The Secretary shall, by notice in the Federal Register, publish the waiver or modifications of statutory and regulatory provisions the Secretary deems necessary to achieve the purpose of this section. This language in the HEROES Act does not mean that as long as the Secretary of Education publishes on the Federal Register the waivers or modifications to the existing laws, he can make whatever waivers or modifications as he sees fit under an emergency. The Secretary's power to make changes is limited by the HEROES Act itself, which only allows for moderate adjustments or waivers to specific regulations. It does not permit substantial changes to the law or to the creation of new laws at will. Even if the Secretary publishes the changes, if the waivers or modifications are too extensive or fundamentally change the existing laws, they could be challenged as overstepping the bounds of his authority as granted by the HEROES Act. In this case, the Secretary's $430 billion debt cancellation plan is not a waiver because it augments and expands existing provisions dramatically. It is not a modification because it constitutes effectively the introduction of a whole new regime. But it cannot be some combination of the two, because when the Secretary seeks to add to existing law, the fact that he has waived certain provisions does not give him a free pass to avoid the limits inherent in the power to modify. However broad the meaning of waive or modify, that language cannot authorize the kind of exhaustive rewriting of the statute that has taken place here. Second, Congress, not the Secretary of Education, has the authority of debt cancellation program of the unprecedented scope. The Secretary of Education argues that Congress, through the HEROES Act, intended to grant substantial discretion to the Secretary to respond to unforeseen emergencies. But the question here is not whether something should be done, it is who has the authority to do it. This is an issue of separation of powers. Justice Roberts wrote, we need to be cautious in assuming that Congress intended to give the Secretary of Education such broad authority. All former secretaries of education have never used the HEROES Act to claim such significant powers. The scale of the Secretary's debt cancellation program is far larger than any prior use of the Act. Taking all of those into consideration, it seems likely that Congress would have intended to make decisions about major issues like mass debt cancellation themselves. But the Secretary's assertion of administrative authority has conveniently enabled him to enact a program that Congress has chosen not to enact itself. In such circumstances, the court has required the Secretary to point to congressional authorization to justify the challenged program. And as explained, the HEROES Act authorizes the Secretary of Education to waive or modify any statutory or regulatory provision applicable to the Student Financial Assistance Program, Title IV of the Higher Education Act of 1965, as the Secretary deems necessary in connection with a war or other military operation or national emergency. But that power has limits. The HEROES Act does not authorize for the Secretary to rewrite that statute from the ground up. Justice Elena Kagan delivered the dissenting opinion. She wrote, "The statute Congress enacted gives the Secretary broad authority to respond to national emergencies. That means when an emergency strikes, the Secretary can alter so as to cover more people pre-existing provisions enabling loan discharges, which is exactly what the Secretary did in establishing his loan forgiveness plan. The court once again substitutes itself for Congress and the executive branch and the hundreds of millions of people they represent in making this nation's most important as well as most contested policy decisions. What can educational administrators learn from this Supreme Court's decision? A key issue is the balance between emergency power and regular procedure. Imagine that there is an emergency and everyone is looking for quick, effective solutions. Now, in such times, with the broad emergency power, it is true that we can bend some rules, pull some extraordinary levers of power that we would not usually touch. But we must never lose sight the core principles of legislation and regulation. Think for a moment a policy you passionately disagree with. Now, imagine the government using an emergency as a pretext, a false excuse that conceals the intention to enforce that policy, bypassing the usual democratic processes. How does that make you feel? During emergencies, even though broad powers may be granted, they are not unlimited and should be exercised responsibly and within the framework of existing laws and regulations.